very brisk canter through the planning and appeal system, and is very much an overview. At the last slide in this presentation is a series of links, and that will give you more information. So the presentation will be broken up into two parts. I'll look at the development plan examinations and the 2019 Planning Act and Planning and Housing Land Supply in the first part. And in the second part, we'll look at planning appeals and how to present your case. So the 1947 Planning Act provided for a right of appeal to the Secretary of State for Scotland if planning permission was refused. There were also a right of appeal for various other decisions that were allowed in that act. And fairly soon afterwards, in the history of the planning system, mechanisms were found for people to be able to make objections to local plans. Originally, the appeal system was administered through different branches within the civil service, depending on the type of appeal. There were a panel of reporters who were effectively consultants, who were usually QCs or retired directors of planning, and ministers made all decisions, usually a junior minister in the Scottish office. The reporters unit was set up in 1973. Reporters were brought in-house, as it were, and became civil servants. We've had various names over the years. We currently call ourselves the Directorate of Planning and Environmental Appeals. Reporters work from home. We've always worked from home, not just because of COVID, and our admin base is in Falkirk. Since 1973, there have been numerous changes to the appeal regulations and how local plans should be considered. And there have been many debates as to what the perfect appeal system should be. But the constant tension has always been between parties' rights and efficiency, the time taken to make decisions. So development planning is really important because that allocates lands for new development. It sets out the policies that will be used to determine planning applications. At the moment, and this will change and we'll come on to that, we have a two-tier development planning system in the conurbations. That's Glasgow, Edinburgh, Dundee and Aberdeen. So in the conurbations, there's a strategic development plan that covers the whole conurbation. And then underneath that, there is a local development plan, which is prepared by the councils within the conurbation. Outside the four big cities, there's just the local development plan. When the strategic development plan will cease when the National Planning Framework is published and will be replaced by indicative regional spatial strategies, a slightly different approach. Development plans focus on land use and place, although the expectation is that they would be coordinated with and take into account all the other policies and strategies that you would expect a council to prepare. In summary, the process for preparing a development plan is that first of all, the council would prepare its evidence base. Then it publishes a main issues report, and that is intended to just be the general planning issues facing the area. It doesn't deal with detailed allocations or detailed policies. And it's the intention of the main issues report is that is the key mechanism for engaging debate and discussion about how an area should be planned. After that, the council prepares and publishes its proposed plan. And at that stage, you're able to make representations to the council about their proposed plan. And if the council can't resolve those representations, then there has to be an examination. And we'll come on to that in more detail in one of the future slides. After the examination, the council has to consider the report prepared by the reporters and then the plan's adopted, and then it's about implementing and monitoring. So if you want to get involved in the planning of your community, it's essential to be involved in the local development plan. My advice is it's important to know what it is you want in terms of the future allocation of land and the future policies that apply to your to new applications, not just what you don't want. Engage as early as you can. Every council will have a website. Every council's website will have a page somewhere about development planning. There will be details of how you can contact your development plan team. And it would be good to make contact and find out what their plans are for the planning of their area. The system is designed to be front-loaded. So the idea is that the main issues report is the forum for debate and discussion. Once the proposed plan has been prepared, that is intended to be the settled view of the council. So if you do have representations to make on the proposed plan, then think about that very, very carefully, because the chances are that will be the only chance you have for your views to be taken into account. And it's important not just to be focus on your representation, but also to be aware of all the other representations that are being made, because many will interrelate. When a plan is at examination with us, you can monitor progress through the website, and you'll be told when the examination report is published. The examination is an examination of the unresolved representations to the proposed plan. Before 2006, the system was objection-based. Anyone could make any number of objections they wished, and every objection had a right to be heard, and many people exercised that right. The reforms that took place in 2006 were designed to speed up the plan preparation process in order to ensure that there was coverage of up-to-date plans across Scotland. So now the council determines the issues. So it's not objection-based. They determine the issues that will be considered at examination, and they group representations into common issues, common topics. And they have to complete a form, which in the jargon is called a Schedule 4. It's based on Schedule 4 of the Development Management Regulations. And that form allows the council to summarise the representations, summarise what the representations are seeking to change of the plan, and then the council will also give its explanation as to why the plan shouldn't be changed, and then at the end there's space for the reporter to do their reasoning and their recommendation as to whether the plan should be changed or not. So the examination report is actually a collection of these Schedule 4s. There would normally be a team of reporters who are appointed to deal with an examination, with one reporter being the lead reporter responsible for coordination and project management. The guidance for reporters is that a plan should be appropriate and sufficient. The actual phrasing in the guidance says a plan does not have to be as good as it could be, it just needs to be appropriate and sufficient. If experience has shown that councils get into difficulty with their proposed plans if they ignore Scottish Government policy or base their decisions with little evidence. There is provisions for holding hearings and inquiries at the reporter's discretion. We occasionally have hearings, but not very many, and there's been no inquiries in a local development plan examination to date. The examination report would then be sent on to the council, and it's for the council to decide what they do with the recommendations in that report, although there are very limited circumstances when a council can set aside the reporter's recommendation. In my final slide, I show a link to Circular 6, 2013, and that gives you a lot more detail about the local development plan process, but some of that will change as a result of the 2019 Act. So that brings us on neatly to the 2019 Act. That received its royal assent in July 2019. And with all major pieces of legislation, there's always a delay between when an act is approved and from when it's actually implemented. There has to be commencement orders agreed by Scottish Parliament. There may be secondary legislation that has to be agreed by Scottish Parliament, and there maybe have to be new guidance written. I think it's fair to say that COVID in 2020 has delayed the implementation of sections of the 2019 Act. A really useful website, which again is on my links in the final slide, is Transforming Planning. That sets out the progress the Scottish Government making in implementing 2019 and also has a lot of information on the National Planning Framework. The initial page doesn't look terribly interesting, but if you persevere and drill down, there is an awful lot of really useful information on that website. The 2019 Planning Act had an awful lot in it. I can only summarize it tonight. For me, the biggest change is the requirement to prepare a national planning framework. In fact, I would argue that's probably the biggest change planning in Scotland since the 1947 Planning Act. Currently, we have a National Planning Framework 3 and we have Scottish Planning Policy, but they're just material considerations. As a result of this Act, those two documents will be consolidated into a single document called National Planning Framework 4, or NPF 4 in the jargon, and that will be an expression of the Scottish Government's planning policies that will apply across Scotland. It will be part of the development plan, and it will have to be approved by Parliament. My understanding is that the intention is that a draft National Planning Framework will be published towards the end of this year, and that they hope they can get through all the various parliamentary proceedings by 2022. There have also been changes to development planning. So I mentioned that the main issues report would no longer be required, and that instead will be replaced by the evidence report. So a council has to prepare and publish an evidence report, and the Act sets out lots and lots and lots and lots of things that the government must corral in terms of evidence of issues in its area. And the intention is that not only is that consulted on, but there would have to be a mini examination, if you like, of that evidence report. And in the jargon, that's called a gateway check. And the purpose of that is to try and ensure that there's a consensus, as much as there can be, over the basic evidence and information of an area before you then progress on to all the other stages of development plan preparation. The actual regulations and the guidance that would be necessary hasn't been prepared yet. So it's hard to know precisely how that will work in practice. My understanding is that that will be published at the same time as the draft National Planning Framework. There are an awful lot of what I would call tweaks to existing mechanisms and parts of the Act. There are also one or two new mechanisms. The two that caught my eye was the master plan consent areas, which is a revamped version of the simplified planning zones, and also local place plans. I've read a great deal of very interesting and exciting things about local place plans. The Scottish Government have published recent research that they commissioned into how local place plans could be used, and they are currently consulting now on the regulations that will apply to local place plans. But again, until we see the guidance, the final guidance and the final detailed regulations, it's difficult to know how they would actually work in practice. The 2019 Act also introduced lots and lots and lots and lots and lots of additional statutory requirements and duties, but they were almost all things that councils had to do in relation to various aspects of the planning system. So Claire asked me to say something regarding the planning and housing land supply. This is a subject which we could have a whole evening session on on its own. It's also a subject that can get incredibly geeky, even for professional planning geeks like myself. I should say that the DPA, we don't have any involvement in the preparation of planning policy. Planning policy, certainly in the Scottish Government, is a matter for the Minister and the civil servants that work for him. We will just apply whatever policy that is in operation. But this is my overview of the situation we face at the moment. So when Scottish planning policy was approved in 2014, there was a policy requirement for councils to maintain a 5-year housing land supply at all times. There was also a policy principle which said there should be a presumption in favour of development that contributes to sustainable development. And the two were linked, because if a council failed to maintain a 5-year supply, then the presumption in favour of development became a significant material consideration. It has to be said that that policy was not radically different to policies that had been applied in Scotland for many, many, many years. However, there were problems in practice. There were an awful lot of arguments and disputes over what methodology you should use to decide whether a council did or did not have a 5-year supply. There were also an awful lot of arguments and disputes as practice stated amounted to sustainable development, but there were also likely to be elements that many would consider not sustainable. As a result of that, there have been several court cases in England and Scotland, with the courts attempting to interpret what the policy means and how it should be applied. The English cases are important because they operate a very similar policy approach down south, and it appears that the Scottish courts keep an eye on English planning court decisions. The upshot of those decisions was that the Minister didn't feel that the court's interpretation accurately reflected his policy intention. So in July 2020, there was a consultation on an amended version of Scottish planning policy. That consultation approach was very partisan, with house builders and development interests arguing that the original policy was fine, that the court's interpretation was bang on, and that there was no further action needed. Many councils and community groups thought that no, the Minister's approach was right. The Minister obviously had to consider those comments, and in the end, a final amendment was published in December, and that is now Scottish Government's planning policy. Subsequently, there has been a judicial review of the publication of that revised policy, and I understand that there's a court hearing of that in mid-April. And we'll have to wait to see how the courts deal with that application. How quickly do the courts resolve these things? Well, several months, possibly more. Whatever happens in court, the housing policy, the future housing policy for Scotland, will be set out in MPF 4. So that's the end of part one. I'll hand over to Claire for the questions.
Thank you, Dan, for that, squeezing it all into such a quick time. I know that quite a number of people have put in questions beforehand. So what I shall do is I shall ask a couple of the questions that came through beforehand, which I've put in the chat anyway so that people can see them. So the first one that came in, Dan, is what data do the reporters feel is most appropriate to have regarding up-to-date housing requirements?
We as reporters don't have a view as such. Whatever is the appropriate data requirement should be whatever is set out in the policy, either in the development plan or in Scottish Government guidance or advice. We will take whatever data is given by the parties to an appeal and we'll do what we can with it. We always encourage parties to try and agree as much data as possible, and we would always try and make sure that any data presentations were comparable. And if that wasn't possible, we might have to hold a hearing or an inquiry to get to the bottom of things.
Susie, have you got a question then?
Yes, I just feel that this is a kind of tick box exercise for the councils, and that they can, you know, override complaints quite easily as they usually do. And I haven't yet seen anything that you've said that makes me feel confident that should somebody wish to, or wish a group, you know, have a strong case against something, that will be, well, that is that something the reporters would deal with?
Well, we only deal if a planning permission is refused, and that's the second part of my presentation.
Ah, right. Sorry.
Okay. Or if there are representations made to a local development plan, in which case we hold an examination. You know, we have to accept that there's a range of views about planning, and you know, as reporters, we will listen to the points of views that are expressed. We'll look at the evidence, and we'll make a decision based on whatever guidance that there is for us. In the second part of my presentation,
right.
I do actually explain how we actually write our decisions.
Right.
So you know, perhaps you can come back to me at the end of the second part,
okay.
and you can let me know whether that gives you any reassurance.
Thank you. Thank you.
We've had a question from John Young. If a local authority fails to notify the Scottish reporter regarding a consented application which is contrary to national policy, the development plan, or a significant development requiring notification, what can be done to hold the council to account?
I don't understand the context that would apply. So I don't understand. So if there's a planning appeal, it would be the appellant that would notify us of an appeal. There's obviously more to this than I understand. Perhaps the gentleman can explain that a wee bit more.
Can I just get a wee bit more about it, get into the detail, obviously. So a major planning application which would normally require notification to the reporter because it's got a national context, would normally be notified to get that basically tick box to make sure it complies with a local plan, etc. However, if the council had not notified the reporter that that application had been consented, and may have actually been consented without being following the correct planning procedures, how would the reporter find out about it? So after the event, how can a community then redress an application which should have been referred on to the reporter for ratification?
Well, strictly speaking, councils don't notify the reporters in those circumstances. There are various requirements where they have to notify the minister. And so it's actually a department within the Scottish Government called the Planning and Architectural Division, which we know as PAD. So there are various, you're right, there are various requirements that you know, if the council is minded to grant something, it has to notify them, and then the minister will decide. The reasoning behind that is it's an opportunity for the minister to decide whether he should call it in for his own determination. So it usually applies where, for example, a national body has objected to a scheme, so SEPA or Historic Environment Scotland, for example. Then there are certain provisions which means that the minister needs to be informed. So it doesn't go to the reporter as such. So the answer is we wouldn't know.
Can I just say that if the minister was not informed, however, that application had been consented, what action can either national bodies or objection groups or individuals to call that back in?
You'd have to go back to the very particular piece of regulation that notification was required for, and to understand what were the implications of failure to notify. And until you knew that, you wouldn't be able to know whether that impacted on the validation of the application or what the situation was.
Thanks. Thank you.
Can I come to a, thanks John for that. Can I come to a question from William Maxwell? In 7 years experience, there's not been a single, there has not been allowed a single presentation by groups questioning development plans. Is our council obliged to allow public consultation?
There are certainly obligations on public consultation. Currently for local development plans. However, I think the form of consultation is a matter for the council to decide. And different councils use different mechanisms, and it's up to the council to decide what would be an appropriate form of consultation.
And I'd just like to point out that Dan has said that he will answer people's questions after, if we don't get a chance to answer them all today. So we will follow up after this event, because we appreciate it's difficult to get everybody's questions asked. This is one from Faye. Do you envisage that the 2019 Act will bring about fundamental changes to local development plans, or will it produce more subtle incremental changes?
Oh, that's a good question. Possibly a bit of both. Can I hedge my bets? I think there are certain elements which will be really different. So the mere fact that there's going to be the national planning framework, which will have national policies, that's going to be very different to what we have at the moment. I think local place plans, depending on how they pan out, that could be very, very different indeed. On the other hand, you know, there's a lot that has been kept to the existing local development plans. So if I'm allowed to give a rather messy answer, I think it could be a bit of both.
Hedging your bets there. Another question, can you let us know in what circumstances the council can ignore the reporter's advice after an examination of the LDP?
Well, the circumstances are set out in the development plan regulations, and you're going to test my memory now. The first one is that no reasonable reporter could ever come to that conclusion. The second one is that it would breach the habitat regulations appraisal, and then there's a third one, which is a really good one, but I can't off the top of my head remember. And I'm happy to answer that question properly when I get a look at the regulations.
Okay, thanks for that, Dan. Another one coming in. If a hearing has been held at the planning stage by a council and the development has been sent to the reporter, will the reporter watch the hearing?
Probably not. If that's a planning appeal, the issue before the reporter is whether planning permission should be granted or not. And I come on to this in more detail in the second part of my presentation. How the council actually reaches a decision is not really of direct relevance to the outcome. The outcome will be determined on the planning merits of the case, based on the evidence that is put up. And once a council makes a decision, you know, it's its decision and is expected to defend it. What I would say is that the reporters don't. It's the council decision that the reporter looks at. It's not what officers recommended. So, and the council has to determine. So the actual, what actually happened at committee, that's not really relevant to a decision.
Thanks. That was one of the ones that came in earlier as well. So let's tick that one off. If proposed development sites in a local development plan were also included in previous local development plans, but were excluded by reporters when they were examined by them, do reporters check and take notice of the comments by previous reporters?
If those are brought to their attention when they're next examining the plan. So it depends whether that would be, I mean, it's quite often when there are disputes as to whether a site should or should not be allocated, that the planning history of those sites would be raised. And in those circumstances, the reporters obviously would have regard to whatever information was given to them. But again, I'll come on to this in more detail in my second part. We can only base decisions on the evidence that parties give. We can't go searching for our own evidence. So we wouldn't systematically go back through past examination reports to find out what previous reporters have decided. It would be for the parties to tell us what conclusions they wanted us to draw in the current set of circumstances.
I had a couple of questions for Dan, if he's still available to answer. A couple of questions on LDP. The 5-year housing land supply calculation, that has now been adopted, yes, by the Scottish Government. So can that be now disputed by developers, or is that it set in stone?
Well, the Scottish Government policy is the policy. That doesn't stop people from arguing that you know, there are particular circumstances which means that that policy should be set aside. So I don't know if it stops arguments. What it does do is set a framework within which decisions can be made.
it should be more clear cut now than it was previously, because they
I
have
think so.
actually come out with the calculation rather than, you know, the council say one thing, the developers say another, obviously to their advantage. So now that they've
Sorry, Gem, I can't.
given the calculation, that should be it.
I think so, but I'm afraid I would be surprised if it stopped disputes.
It won't stop them. Right, I've got one other question quickly. Now, they talk about the weight that's given to an emerging LDP, and the closer it gets to finalisation, the more weight is given. Now, what happens to an LDP? What weight is given to an LDP that is with ministers at the moment? It's being examined, but where it's contested. So, do you know, can we use the new LDP at all in future? Do you know, can we use it at all at the moment, or is there any weight given to it where it's contested?
There's always weight. So we need to go back to the legal basis for the decision. So a planning decision must be made in accordance with the provisions of the development plan, unless material considerations indicate otherwise.
Right.
Now, what is or is not a development plan is a matter of fact.
Mm-hmm.
So it's whatever is the adopted plan at that time. That is the development plan.
Right.
So anything which is emerging, so if it's at examination or it's with the minister or for whatever reason, but it's not yet adopted, then that will just be a material consideration, and it will be for the decision maker to decide how much weight to attach. So it depends on the circumstances.
Right. Thank you.
Thanks, Dan. There was one final one that I just wanted to flag up because it's from Alice, and I know how much of a hard time Alice has had. And she says, why is this all so complicated? Why do communities have to face this complexity? Well, I would say that, you know, that is what planning democracy is kind of here for. It's to try to campaign for a fairer and more sort of neutral planning system, and one that communities can engage with better. And I was joking with somebody earlier today that, you know, if you go for an MRI scan, you don't have to know how the MRI scan works in order to get a diagnosis, which seems to be somewhat different with the planning system. You seem to have to know how it works to engage with it properly. So on that note, I shall just say that we're going to have a 5-minute break, and then we will come back and we will learn more about appeals from Dan.
So in this section, we're going to look at the planning appeal system and how you can make representations. Before the 2006 planning reforms, we dealt with every planning refusal throughout Scotland. But after those changes, we only have jurisdiction if a planning permission is refused by the planning committee. If a decision is taken by a planning official, then the right of appeal is to the local review body, and we have no involvement in that. The 2006 changes also were designed to reduce the time taken to issue planning decisions. So there is no right to be heard. The matter of how an appeal is determined is for the reporter to decide. And again, the system is designed to be front-loaded. So there's only one guaranteed chance to make representations. There may be other opportunities, but there's only one guaranteed chance. So the default process for determining planning appeals now is an unaccompanied site visit, written grounds of appeal from the appellant, and then whatever material was before the council. And 62% of appeals were determined in that way in 2019. I'm using 2019 figures because 2020, for obvious reasons, was a rather peculiar year. So what does a reporter do? So when an appeal is submitted to the office, and 86% are submitted electronically now. The office collects them up and groups them into batches which are drivable within a day. And the office then allocates those to each reporter. We don't specialise in appeal types or areas, and an email just comes in telling you that these are your new cases that you have to work on. Your first job is to review the material online to determine whether the default process is appropriate. If it's not, you would prepare a procedures notice, and we'll come on to that in a minute. You would arrange your site visit, and then you would prepare for and complete further procedure if you had to do that, and then you would write your decision up. And these batches come thick and fast. You get one of those emails in your inbox every 2 weeks or so. So how does a reporter decide what procedure to follow? Well, we would take into account the views of the main parties, that's the appellant and the counsel, and there's space on the respective appeal forms for them to tell the reporter how they think the appeal should be determined. You have a choice of further written submissions, a hearing session. A hearing is a structured discussion led by the reporter. It's not quite the same thing as a hearing that the counsel holds. And then, or an inquiry session. An inquiry session is more formal. It's a bit like a court, and witnesses can be cross-examined. The test for the reporter is what is necessary to make the decision. Can the reporter understand the position of the parties? And if there is a dispute, are the reasons for those differences clear? You would use further written submissions if you had specific questions you wish to ask one or all of the parties. Perhaps there was a new policy or there was a procedural matter you wanted to go into. And further written submissions were used for 128 appeals in 2019, just over a third. You would use a hearing if the dispute was a matter of opinion or planning judgment, which was too complicated to be resolved in writing. And in 2019, there were 7 of those. You would use an inquiry where cross-examination was essential, perhaps because there was a dispute over matters of fact, or it was a highly technical matter. Sometimes inquiries are essential, but they're increasingly rare. There were only 3 in 2019. I should just say those figures relate to planning and planning related appeals. The DPEA does lots of other types of appeals like Section 36 wind farms, compulsory purchase orders, road orders, etc. Those are determined by other legislation, and for those different types of appeal, hearings and inquiries are much more common or even required. So I thought you might be interested to know how a reporter actually goes about writing up a decision. So the first thing you have to ask yourself is, what is before me? What is the question I have to answer on behalf of Scottish ministers? So if you had a planning permission appeal, the question before you is whether planning permission should be granted or not. We had a question earlier, how the council made that decision, whether the planning officer was any good, whether the developer was a cowboy or not. None of that is relevant to the actual question before you. Also, you have to address whatever statutory tests or duties apply to that particular type of appeal. Every type of appeal will have some kind of statutory test or duty. If it's a planning permission appeal, it's Section 25. which is that the decision should be made in accordance with the provisions of the development plan unless material considerations indicate otherwise. If it's an enforcement appeal, there are statutory grounds of appeal. If it is an advertisement appeal, then the decision, the only things you consider are public safety or amenity. A reporter will get into trouble in the courts very quickly if they do not address the statutory tests and duties. You have to rely on the evidence that is given to you. A reporter cannot go looking for their own evidence. So if an appellant has some highway consultants and they argue that a road junction has to be designed in this way, and you have the council's road department which says, no, 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 you have to design a road junction this way, a reporter can't go on roadjunction.com and say, no, you're both wrong, you have to design a road junction this way. You have to provide adequate reasoning for your findings. Now, books have been written about what adequate reasoning means, but in essence, it means for every finding, the reasons for that finding have to be logical, intelligible, and the losing party must know what it is that they've done wrong. You have to address all key relevant matters. Doesn't mean you have to address absolutely everything anyone tells you, but you do have to address the key matters that the decision will turn upon. And you have to ignore irrelevant matters, either by not mentioning them or mentioning that they are irrelevant. You have to write your decision up positively. And by that, what I mean is you're not giving polite feedback at a job interview. So you couldn't say, well, both sides made some extremely good points. It was so difficult to decide between you, but on balance, I just think the council edged it. You've got to positively make a finding, even though we all know planning is rarely black and white and often shades of grey. You can't indicate what would be acceptable, even if the parties ask you to. So if you had a proposal for a 4-storey block of flats, you couldn't say, well, I think 4's over-egging the pudding, but if you knocked a story off and it was 3 stories, that would be fine. The reason for that is that by doing so, you would fetter a future decision maker. So the correct course of action is to clearly explain what you think is acceptable or unacceptable about the scheme before you, and the parties have to draw their own conclusions. You have to be accurate, certainly factually accurate, and we encourage reporters to write in a concise style. Once a planning appeal decision has been issued, only the courts can change that decision. And they would do that by quashing it. And if a decision is quashed, then it returns to be reallocated to another reporter who would redetermine it in the light of whatever the court had said. And the courts will only quash a decision on a matter of law. They will not look into the planning merits or the planning judgments that were exercised. So what should you do if you get involved in an appeal process? How can you best present your case? Well, the first point I'd make is actually there's no silver bullet to guarantee that you will be able to persuade a decision maker. In fact, I would say whether you are able to persuade a decision maker of your point of view is probably not completely in your control. The only thing that is in your control is making sure you explain your position clearly. So my advice would be to focus on making sure you clearly explain your position and not worry too much about whether you have actually persuaded the decision maker. You need to answer the question. Beware of the decision-making framework, which we just discussed in the previous slide. There's no point talking about and writing information about things that a reporter can't take into account in a decision. Give reasons to explain your position. Avoid assertions. So don't just say this new building will be ugly and stick out like a sore thumb. Explain why. Explain it's higher than the surrounding buildings. It's a different architectural style. It has different materials. It has different proportions. And avoid making exaggerated claims to make a point. So if you say that the traffic from this development will clog up the junction down the road and that will back up for miles and miles every day, do you really mean that? Do you really mean miles, i.e. more than a mile? Do you really mean every day? Is that Sunday? Is that school holidays? Is that Christmas Day? Because if you make exaggerated claims, it's very easy for the other side to disprove them, and that discredits your evidence. It's really, really good to submit supporting documents that help your case. And a supporting document can be photographs, it could be your own surveys, or it could be other publications that help your case. But if you do that, make sure you clearly cross-reference how the reporter is to find those things. Make sure if there's conclusions you want the reporter to draw, you clearly set those out. Don't just submit 20 Scottish Government publications and leave it up to the reporter to work out what it is you want them to make of it. Make your statement easy to read, and by that I mean have a logical structure. Within that structure, have a logical ordering of points. A reporter will always read whatever is submitted to them, but why would you want to make it hard work and difficult? Use the case officer. So every appeal will have a case officer who's responsible for the administrative work. They don't have any involvement in the decision itself, but they do the administrative tasks and look after the file. They're a great source of procedural information and information about deadlines. Also use our website. So all the current appeals that we have are on our website, and all the material that is before the reporter is on that website. So you could use that to see how other cases that are similar to yours, how they have submitted information, and pick what you think works and ignore what you think doesn't. So what should you do if your appeal case becomes a hearing or inquiry? So the first thing I would say is that reporters completely understand that no one is born understanding how a planning hearing or an inquiry works. Unless you're a property professional, the chances are any involvement in a hearing or inquiry will be a once-in-a-lifetime experience. And you're bound to be nervous and unsure of something that you're not familiar with, and that's understood. Although I have to say, the parties I speak to after a hearing or inquiry usually find it's not too bad. So don't panic. It's not a sudden death playoff, and the reporter will understand. The vast majority of the evidence that was before a reporter, even in a hearing or inquiry, will be written material. The actual verbal evidence that as a reporter you hear at hearings or inquiries is a very, very small proportion of the total amount of evidence that is before you. Most of that is written material. So all the advice I just gave in the previous slide would apply to hearings and inquiries. I'm afraid there is a lot of jargon involved in hearings and inquiries, and strange names given to things like precognitions and hearing statements, cross-examination, re-examination, closing statements, etc., etc. If you're not sure, just ask, ring up the case officer, We have a website which is on my list of links, which has various guidance notes, including an explanation of commonly used terms. Combine and also a lot of hearings and inquiries are now webcast, so you can go on our webcast site and you can actually view previous hearings and inquiries, and you can see what is involved. If it's at all possible, combined with other parties or people who have a similar point of view as yourself, combining is not a sign of weakness, it's a strength. It will share out the work. If there is a group of you, then pick a small team who is actually going to lead. My advice would be 3 or 4. If you have too large a number of people who turn up to inquiries or hearings, you will just trip over yourselves. And have clear roles as to what you're going to do. So perhaps you nominate one person who would mainly answer the questions. You would nominate another who would be responsible for finding the documents, and you would nominate another who would just come in at the end to sweep up and give the concluding remarks. And again, that's why it's useful to have a look at our webcast site and look at how other parties deal with hearings and inquiries. If you are in discussion at a hearing or you are being cross-examined at inquiries, understand that every argument will have assumptions or premises underpinning the basis of that case. So make sure you understand what are the underlying assumptions underpinning your case, because that is where you're likely to be attacked from the other side. And if you're thinking of questions for your opponents, again, think about the fundamental assumptions underpinning the arguments that they're pursuing. So just to pull all that together, the current system is designed to be front-loaded. Get involved in the national planning framework, get involved in local development plans, engage constructively with pre-application notices. Don't wait just for planning applications. If you just wait for planning applications, you will find out that a lot of decisions have been taken before you get involved. The current process is that we apply prioritizes efficiency, and in its own terms, that works. We do actually have largely full coverage of up-to-date local development plans in Scotland, which has not been the case for very many years. And the time we take to deal with planning appeals is between 12 and 20 weeks on average, and that is a significant improvement on how it used to be before the 2006 changes. Be aware that reporters and the planning minister have to follow a decision-making framework when we make planning decisions. It's not as simple as just deciding which side you agree with. If you're having to make submissions, don't worry too much about persuading the decision maker. Focus on how you can set out your position clearly and justify it as much as you can. Obviously, in an appeal system, not every point of view can prevail. That's the nature of appeals. One party will always be disappointed. But in 2019, 58% of planning appeals were dismissed. So that's, I'll hand over to Claire for questions once I stop sharing. Right.
Okay, thanks, Dan. Just to point out, for those that are waving at me to ask questions, I can't see you all, so you have to put them in the chat. That's why we're using the chat function. If you're having difficulty, I do apologise, and maybe you email us afterwards if you're really struggling. So some of the questions. What weight is given to an emerging local development plan that is contested now that the 5-year housing land supply calculation has been adopted? Did you get that question?
Whoa, there's two separate things there. So if it's a planning permission appeal, the starting point is section 25, which says that a decision should be taken in accordance with the development plan unless material considerations indicate otherwise. So what is or is not a development plan is a matter of fact at any point in time. So that's your primary starting point. So you'd have to look at whatever was in that. If there was an emerging local plan or there's government guidance, that is strictly material consideration, and it's for the reporter to decide how important that is relative to the provisions of the development plan.
This one's regarding attendance at hearings. What happens if community reps can't make it to the hearings? You know, they've got busy lives, whereas the developers are there to just do that. You know, how does that work out?
Well, so if a reporter was arranging a hearing, then the dates and times would be agreed with the parties who were entitled to take part. And yes, that can sometimes be difficult, and we have to play around with diaries. Sometimes hearings have taken place in the evening. Sometimes they have taken place at weekends to allow and accommodate people's diary commitments.
Thanks. I had a case where the council's planning committee unanimously refused the developer's application in support of community objections. At appeal, the reporter upheld the reasons for refusal, but upheld the developer's appeal. How is that justifiable?
Well, the basis of the appeal system is that when an appellant submits appeal to Scottish ministers, which we determine on the Scottish ministers' behalf, the reporter is deciding the decision afresh, and the issue is a planning judgment based on the planning merits of the case. So the council has an opportunity to put its case, other people have an opportunity, the appellant has an opportunity, and the reporter has to make a decision. And that's how our appeal system works. That I completely accept that there are people who don't agree with the current system. You could have a system where you said, well, you know, a council's decision is final, but you would have to be really sure that is what you wanted.
There's somebody called Kerry, is that right? Who people are advocating could ask their question.
Okay, Kerry, do you want to come in?
I just wanted to know, what's the next stage? Renfrewshire Council voted to reject the reporter's analysis on the local development plan. So what follows on from that?
Well, that's a matter for the council. They have to decide what to do with the reporter's report. I don't know the details of that report or the details of the council's motion. You would have to look to see what it was precisely saying. And there are a number of options available to them. They can just abandon it and start and do another plan.
I think it was purely a matter of one small site on the land supply, which the council was not prepared to change and to do anything about, and therefore the 9 of the planning board voted to reject the whole plan because they were not allowed to change on the one land supply.
Right. Well, that's a matter for the council to decide. What that will mean is they won't be able to adopt that local development plan
Okay.
Advocates, beneficial to have an advocate or not through an appeal?
I'm sure if I was a community group, I would take comfort if there was someone helping me. I don't think it's essential, and it's certainly not the case that only professional planning teams represented by Queen's Counsel win appeals and no one else does. That's just not the case. So I can see why it's always helpful to have advice and support, but I don't think it's essential to participate in the planning system with an advocate.
I'll try and ask another 3 questions, and I'll just want to reassure people that if we can't manage to ask them today, we will try and answer them in follow-up emails, okay? Because I appreciate that must be quite frustrating for you. You said 58% of applications, is that the ones in the LDPs? Many of them are which are speculative. You gave that figure, I think, didn't you?
I said that 58% of planning appeals are dismissed. I couldn't tell you how many were contrary to the LDP or not. I'd have to go through all 600 appeals, which I'm not. I'm reluctant to do. But so that percentage was the headline decision rate for planning appeals, just planning appeals.
Yes, that's a bit of a shame that we don't sort of somehow document the ones of the contrary. I guess this is a bit related. Does the reporter's decision-making framework include anything about how far away from a development plan an application has to be before it's not in accordance? Perhaps the basic question is, what does in accordance mean?
Well, so ultimately, what is or is not in accordance with a development plan is a matter of planning judgment. So the courts have given guidance on how decision makers should address that, and what you have to do is look at the objectives of the relevant policies of the plan. You have to look at the detailed wording of the plan that are relevant to the proposal, and then you have to decide overall whether the proposal is complies or not. And of course, it can often be the case that there'll be elements of a proposal where there is support in the plan, and there'll be elements that are against it, and so that is a matter of planning judgment.
And I guess this is a little bit related as well. How do you weigh up environmental considerations versus economic development ones?
Well, so, you know, environment and economic, those are big things. Those are big issues. In terms of making a planning decision, one wouldn't be seeing it as in that kind of division. Again, if it's a planning appeal, your starting point is whatever the development plan says. You would like to think when a council prepared the development plan, it had thought about the balance between economic development and environment. There may well be other factors that you'd have to consider, which are economic and environment factors. Ultimately, that is a balancing exercise, and again, the reporter would have to make a planning judgment based on the evidence that the parties had given.
And a final question is your appeals handbook, which you mentioned in your presentation. Now, Scotland Against Spin, I believe, in the stakeholder forum that you have, that also Planning Democracy have been part of, and I was wondering whether you might say a little bit about that stakeholder forum, and also you know, a little bit about how you've advertised this handbook, because it is very good, And just to point out that Planning Democracy are doing a different handbook, and we will be using a lot of the questions that are asked tonight to inform our appeals handbook and our housing land supply one. But yeah, could you just say a bit more about that?
Right, well, the stakeholder group. So yes, we every 6 months or so, we invite people who are, if you like, regular customers of the appeal system. That can be representatives of councils, legal people, statutory consultees like Nature Scott and SEPA and the like, and various other campaign groups such as Planning for Democracy and various other interest groups, to discuss and give us feedback as to how we're implementing the system. So that's the purpose of the stakeholder, to help us improve how we manage the appeals service as best we can. We do have a whole series of guidance notes, including the booklet that you just referred to, Claire, and that's on our policy, what I would call our policy webpage, and that's one of the links. We used to have what I thought was a helpful website, but then we had to conform with corporate guidelines, and so it's all thrown into the bigger Scottish Government's website, and it's not the most helpful site to get through, I don't think. But yes, that's on that. Also, if you actually have an appeal, then just give the case officer a ring. Also, well, at the moment, you probably have to send an email. They'll be more than happy to help and give you advice or direct you to whatever guidance we publish.
Thanks, Dan. That was good, and I do apologise if we haven't been able to ask your question, but I once again reiterate that we will be trying to follow all questions up in various formats and means. So rest assured, we're going to do our best to answer all your questions. Helen.
Thanks. I think we're just going to go over to Sam for a moment, are we? Or I saw there was a question about a forum for discussing this. Sam, are you there?
Yeah,
Yeah,
I'm here. Hi there. I think Felicity brought it up. So yeah, I won't take too much of your time, but my name's Sam Buckley. I'm a trustee here, so I actually focus on things like digital communication. Dan's given some really good points today about how we can engage with quite a complicated system, but I suppose the question is that we can't really leave it there. So there is a space to actually continue the discussion. So if you want to be a part of the network, then you just need to email Plan Democracy email address, which I've put in the chat, and we will send you a link to it and give you a guide to help you engage with it. It's on Slack, so if you're new to that, don't worry, the guide will help you through it. But yeah, that's how you engage with that. Thank you.
thanks, Sam. And now back to Claire, just for a couple of final remarks.
Yeah, I just wanted to say thanks everybody for coming. We spend a lot of our time campaigning for a lot of the issues that have been raised tonight to try to make the system fairer. We realise how frustrating it is for people. We hear from people an awful lot asking for advice. We do have a number of planning mentors, so if you have any knowledge, you might not think you've got a lot of knowledge, but you probably have, so please do join or email us to join our planning mentor group, where you can either provide assistance to others, maybe helping them through an appeal process, for example, if they haven't done it before. That has been a very useful thing to sort of get everybody working together to help sort of engage people in planning a bit better. So do get in touch if you want to either volunteer or become a planning mentor, or indeed if you've got any further inquiries or want to have help from a planning mentor yourself. We do have a website. It's www.planningdemocracy.org.uk. We've also got a Facebook page, and we occasionally engage in Twitter, but not that often. We don't really like Twitter. If you found tonight helpful, please do tell more people about us. Please consider giving us donations by going to a donations page on the website. We are largely voluntary, and the only reason we can do things like write our booklets and our guides is if we have generous donations from people such as yourselves. So please do consider giving us a wee donation. Many thanks for coming, everybody. Is that about it? Helen, are you wanting to say anything more?
I was just going to say, I think we should all say a very, very big thanks to Dan for his time this evening. It's been really fantastic, and I think virtual claps are going on around. Thank you very much indeed.